Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. On the other side of the aisle, the U.S. District Judge overseeing the case against President Trump on these classified documents charges has now set an initial trial date of August 14th. In Florida, and you can presume probably that will get pushed back, although how much is probably up to President Trump and his lawyers, how many appeals and how much wrangling over the legal issues they want before they get the trial date set. And Kim, notable that President Trump has cannonballed into the pool again with an interview with Fox News' Bret Baier. And it's probably worth playing a few clips of that. But let's start with this one. When he says NARA, he's talking about the National Archives and Records Administration.
They raided my house. They came in and raided. We were discussing, having very good discussions with NARA, a radical left group, by the way. And all of a sudden, my house got raided.
Do you know if you still have any highly sensitive government documents?
No, I don't have anything, no.
Okay.
But what I'm concerned about, they took everything, right? I don't know what they took. They could be stuffing it. I don't know what they put in there. And we wanted to be there when they were taking. They wouldn't let anybody in the room. They've never treated a president like this.
And here is President Trump explaining why he kept the documents that he kept.
You say on tape
it says just the opposite.
that you can't declassify it, so why have it?
When I said that I couldn't declassify it now, that's because I wasn't president. I never made any bones about that. When I'm not president, I can't declassify.
And that's what you said. You didn't declassify it.
I said no. I said I couldn't.
But
that wasn't a document, Bret. There was no document. That was a massive amount of papers and everything else talking about Iran and other things. And it may have been held up or may not, but that was not a document. I didn't have a document per se. There was nothing to declassify. These were newspaper stories, magazine stories, and articles.
I'm just saying what the indictment says.
Well,
the recording and the people in the room who testified.
These people are very dishonest people. They're thugs.
So, Kim, I think that's notable because the indictment says there was a classified document from the Pentagon about an attack plan on another country. And President Trump is basically denying on the record there that he had any such thing. And I wonder whether he is creating potential problems for his future defense by going on the record like this and backing himself into corners and maybe eliminating avenues of defense that his lawyers might want to take later on.
Well, the interview was fascinating because it did preview a couple of what obviously are going to be Trump defenses. Notably, they're different from ones he's made in the past. Remember, he at one point claimed that he had declassified all material prior to taking it away. That seems to have gone by the wayside. He made two interesting cases here. One was, as you just noted and as that clip revealed, suggesting that whatever was going on in that particular meeting, and it had to do with a book that his chief of staff, a former chief of staff, Mark Meadows, was writing, that there was a mass of stuff on his desk in that there wasn't specifically a classified document. Now, it is kind of interesting if you just look at the immediate lead in to that part of the indictment, it is where they don't specifically describe a specific document. And so I don't know if that's something just that his attorneys noted. This is now where they're going with it. But one thing that will be really curious is whether or not there are any witnesses or people who are called to the stand that make the case that there was actually, in fact, a classified document that was being waved in the air. The other interesting case that Trump made was that all these boxes had been sent down to Mar-a-Lago. He hadn't had time to look through them all. It was his intention to do so at some point, but he didn't want to just hand over these boxes back to NARA until he'd had the opportunity to do so, because all of this stuff was mixed up together between his personal belongings and what we now know were classified documents. So his suggestion being that, in addition, you heard him as well say, too, we were having good discussions with them. We were going to get it. I think his argument is going to be, look, I had never had any intention to willfully keep these. hadn't had a chance to go through the process, and I was always intending to get it back. Now, that is fascinating to me because that kind of falls more into the argument that this was kind of just an oversight on his part. It would have got there if they'd given him some time, but this was not an intentional attempt to keep classified information.
And let's do one final clip from President Trump.
So you're not worried about this case?
Based on the law, zero. Presidential Records Act, plus the Clinton case, which was won by Clinton as president because he took tapes of leaders in his socks. Zero.
Okay.
Zero. And every good lawyer has said it, and you've seen that. Every good lawyer has said that.
Obviously, there are others who push
saying?
back. And
this was a weaponization of politics. This was a weaponization of the White House. This was a horrible thing.
So, Kim, this is another defense that President Trump's advocates are raising. These tapes of President Clinton's that he's referring to were recorded by the White House, apparently between President Clinton and a historian who was visiting him over the course of many years. And the argument is that President Clinton took those tapes and designated them as personal records, and the National Archives had no right to overrule that. That is what a court held when the group called Judicial Watch was trying to get access to those tapes. But I would point to the text here of the Presidential Records Act, which says that personal records are purely private or non-public character, do not relate to or have an effect upon carrying out of the constitutional duties of the president, including diaries, journals, other personal notes. And so, Kim, I guess the prosecution's argument would be that case is distinguishable because when President Clinton meets with a historian and tapes their conversation, that is akin to a diary, a journal, personal notes, purely personal records, not the kind of things that we're talking about in this case with President Trump. And we'll give you the last word.
Yeah, I mean, that'd certainly be what the prosecution would argue. I think that what the defense will argue, what the Trump team will argue, is that one notable feature of that case was that, and the Judicial Watch attorneys hit on it very hard in this, is that while Mr. Clinton might have designated these as personal records, and while a lot of the records did involve him musing about situations and places, they also contained phone calls that he made to U.S. senators, a phone call he made to a House Democrat, a phone call with the Secretary of State, for instance. They also noted that these meetings were set up and conducted and taped by paid White House staff. So Judicial Watch was making the argument that these were, in fact, they did include elements that would normally be taken by NARA as presidential records. They're also going to point out that, interesting, the Justice Department argued in that case in defending NARA that it didn't have a duty to engage in a never-ending search for potential presidential records. And then the judge in the case, Amy Bourbon Jackson, I will just read his, and this will come down to the dispute. The dispute is not what you read in that text in the Presidential Records Act, but who gets to decide what is or is not a presidential record. And she wrote, since the president is completely entrusted with the management and even the disposal of presidential records during his time in office, it would be difficult for this court to conclude that Congress intended that he would have less authority to do what he pleases with what he considers to be his personal records. So again, who knows where this goes? And I have been saying this from the beginning. We are in completely uncharted legal territory here, which is why I kind of keep laughing at people that go, oh, this is just a cut and dry case. I don't think it is. There's a lot is going to need to get explored. But one thing I think we can both agree on, Kyle, is that this is not getting heard on August 14th. Former President Trump has every interest in pushing this off until after the election, and they have a lot of means by which they can argue in pretrial motions, etc., and push this off.
Thank you, Kim. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.